Hey, what's happening? It's Bill Smith. I'm not sure if this is a future proves past kind of moment here, but we got some really great news about gun rights today. I'm going to cover that in a second. Here's a couple Q posts that talk about gun rights. Guns are safe. Guns are safe. Back in March. This is right around the Parkland stuff. So I think David Hogg, is he the guy from Parkland that became like the celebrity? I think he went to school in California or something. I don't know. I mean, there's all kinds of like rumors swirling about that online. I'm not supposed to talk about that. But Q said guns are safe. Guns are safe. We were freaking out a few months ago because if you remember, Trump was talking about banning bump stocks and all kinds of other stuff. I mean, he was saying he was going to give the Democrats everything. So obviously that didn't happen. Okay, now the weird part is today. This is the best part. Best news you're going to get in a while. Appeals court says the Second Amendment allows open carry of guns. And the headline is crazy, but the fine print is even more unbelievable. Like wildly awesome. So this is the most liberal federal appeals court in the country. So I doubt this is going to the Supreme Court. I don't think the Supreme Court will hear this. I think this is it. I think this is the ruling. We'll see what happens in the next week. I just don't think it's going to go to the Supreme Court. I think this is it. So I'm going to talk about this like this is the law of the land now, because I'm pretty sure that that's what this is. This now is the law of the land. You can open carry a gun, a handgun, in public now. Now the interesting part is like California has some of the most strict gun laws in the country, along with Hawaii. And this case comes out of Hawaii, where this guy said, I want to have a handgun for self-defense, and they wouldn't give him a permit. So then he sued. So now it turns out you don't even need a permit. So if Hawaii would have given him the permit, he wouldn't have sued, this wouldn't have happened. So I think Hawaii overstepped their bounds. They've been trying to regulate guns out of existence. It hasn't worked. Now the court said that you don't even need a license to carry an open carry a gun. Okay, now I'm going to read this article to you. It's really short. It says a federal appeals court has ruled that the Second Amendment right provides the right to openly carry a gun in public for self-defense. Now this is really important. This is super important, the last part, because you can't use a gun for self-defense if it's not loaded. You know, unless you're going to hit somebody with it, but that's not the purpose of a gun. So you can't use a firearm unless it's got bullets in it. So you can't use it for self-defense unless it's loaded. So it basically says that you can carry a loaded handgun openly in public. So the article goes on to say, it says the Ninth U.S. Circuit Court of Appeals ruled Tuesday that Hawaiian officials have violated George Young's rights by denying him a permit to openly carry a loaded gun in public. The 2-1 decision reversed a lower court decision that sided with officials who said the amendment only applied to guns kept in homes. So the state of Hawaii argued that the Second Amendment only applies to guns kept in homes. Not a very good argument. So the panel, these are the three judges, said that, quote, for better or worse, the Second Amendment protects the right to carry a firearm in public for self-defense. Okay, now because we're talking about laws, I want to make sure that I get this in this video here. This is the actual ruling from the United States Court of Appeals for the Ninth Circuit. The most liberal circuit court, okay, in the country. So down here it talks about this, and it says the panel acknowledged that while the concealed carry of firearms categorically falls outside the Second Amendment, so they're talking about concealed carry they're acknowledging that concealed carry falls outside of the Second Amendment protection. It was satisfied that the Second Amendment encompasses a right to carry a firearm openly in public for self-defense. Analyzing the text of the Second Amendment and reviewing the relevant history, including founding-era treatises and 19th century case law, the panel stated that it was unpersuaded by the county and the state's argument that the Second Amendment only has force within the home. The panel stated that once identified as an individual right focused on self-defense, the right to bear arms must guarantee some right to self-defense in public. The panel held that because Hawaii law restricted the plaintiff in exercising the right to carry a firearm openly, it burdened conduct protected by the Second Amendment. So there it is. The courts ruled you can carry a loaded firearm, a firearm for the purpose of self-defense in public. Okay, now what I just read you encompasses a lot of different stuff, and it applies to California kind of in some odd ways. So you can come take a look at this actual penal code. This is the law in California about carrying firearms. You are not allowed to carry a loaded handgun under any circumstances in California, at least up until yesterday. Now, the Federal Court of Appeals, the Ninth Circuit that governs California, says that you can. So take that as you will. So before, here's the law. I don't want to bore you with the whole spiel of it, but it does say both loaded and unloaded handguns are illegal to carry anywhere in public. So you can carry, the California law as it's written right now says that you can carry an unloaded gun in your car to transport it, and you can keep it loaded if it's in your house or if you're at a firing range or something designated for that gun use. But other than that, you can't have your gun loaded. You can't have it outside your car. And you can't even have it inside your car if you can reach it. It has to be like in the trunk. So that all goes away. All that goes away. Now in California, I don't think that you could conceal it. This is going to get complicated. So I'm not sure in California if you could load your gun and put it in your glove box and lock it. But I know that you could load your gun now and leave it in the front seat next to you in plain view, because that's not concealed. So this whole California law is either going to get washed away or rewritten. I imagine California is not just going to take this lying down. I think California legislature is probably going to get on this. And I'm going to show you some other evidence of some other breaking news that I think is just as important. All right, so this just happened last week, and this is the same court issuing rulings against gun ownership rights. So they ruled in the favor of gun ownership, and they allowed an injunction against California's high-capacity magazine ban. The interesting part about this is that this was triggered in 2016 on a vote by the actual citizens of California, who said, we don't want large capacity magazine bans starting July 1st, 2017. Now, since 2000, large capacity magazines have been banned in California, but the law had a grandfather provision which allowed people to keep the magazines they already had. So basically, you couldn't buy and sell them in California, but you could own them. And as long as they were made before 2000, you could claim the grandfather clause. This Proposition 63, though, removed that clause and required people to get rid of it, remove it from the state, sell it to a licensed dealer who could remove it from the state, I guess, or surrender it for destruction. You weren't even allowed to have them. So it criminalized a lot of things that people bought legally and had owned legally for 15, 16, 17 years by this point. So I guess there was an injunction against it. This law has not taken effect. I guess that's what that means. At the bottom here it says, earlier today, a Ninth Circuit panel affirmed the district court's grant of the preliminary injunction. The panel found that the lower court did not abuse its discretion by concluding that, quote, magazines for a weapon likely fall within the scope of the Second Amendment. The opinion also stated that the district court did not abuse its discretion when it found that the challenged statutes did not survive intermediate scrutiny. Okay, so this is the interesting part. So for a law to survive a constitutional challenge, so if they do rule that it's a Second Amendment issue, rifle magazines, which it sounds like it is, and they've already signaled that they're probably going to rule that it is, then it has to survive the scrutiny, which requires that a law further an important government interest and do so by means that are substantially related to that interest. Basically, it has to reduce deaths, or it has to reduce, people killed by a magazine being bigger than normal. And, I don't know if statistics are going to back that up. I think that'd be a tough case to make. So I bet that California is going to get the ownership rights back on high capacity magazines. So as of now, as long as you have a high capacity magazine that was made before 2000, as of right now, it is still legal to own that in California. Also, it's legal to openly carry a handgun, a loaded handgun, in California. Good news for us. Now here's that appeals court decision I was just talking about. I don't think it's been published. It talks about this guy named Xavier Becerra in his capacity as Attorney General of the state of California. So he's the defendant. If you want to go look him up, I'm sure you can find him over here on the opinions. I think it's on the unpublished list. So opinions, unpublished. There it is. I'll leave the links. I'm going to cut this video short. Before I do that, though, I just want to show you that it doesn't look like Google's up to date. So Google here talks about what I mentioned earlier. It says our high-capacity 22 magazines legal in California. It says that the ban does not include any 22 caliber tube ammunition feed device, any feeding device that has permanently altered so it cannot accommodate more than 10 rounds. So it talks about having a plug in it. There's more rights here. Like I said, it's just difficult to navigate gun rights in California. So the fact that we got this court decision today that affirms that you can carry your handgun in California open in Los Angeles or San Francisco, that next San Bernardino Muslim attack, right? You can shoot back. I think that we're making gigantic strides. So guns are safe. Trust the plan. I'm actually kind of surprised about this whole thing because I didn't think that we would make progress. It looks like we just made progress. I was just trying to make sure we keep what we got. We don't slide the rest of the country in the way of California looking for serialized bullets. Good news. Until next time, it's Bill Smith. Thanks for watching.